Senator Lee.
Thank you very much. At the outset, I want to note that the Federalist Society, which is commonly becoming a whipping boy these days in these committee hearings, has one substantial difference from other legal organizations in my experience. At symposia held by the Federalist Society, unlike many others, most others, all others, I would say, they tend to have opposing views when they have panels. They don't have panels that are love fests where everybody takes the same position. They invite people from the left and the right and everywhere along the political continuum. The difference is they're interested in hearing from more opinions. It's more than I can say from many entities that operate within the ABA-accredited law school arena. The Federalist Society provides a valuable service. And to characterize it simply because many, if not most, of its members happen to be more conservative, and in that respect maybe differ from those in legal academia and within many parts of the practice of law, is not being fair. It's not being fair to this process or to the Federalist Society. Judge Brasher, in the time that you've served as a judge, why don't you tell me a little bit about some of the cases that you've handled?
Sure. So, Senator, I've handled the full panoply of cases that federal district court judges handle. Most of those cases arise on the civil side. Most of them arise under federal statutes such as sexual harassment statutes, Title VII, things like that. On the criminal side, I've handled cases also arising from the full panoply of federal criminal laws, from white-collar crime cases to drug and gun cases. As I said in my opening, I've sentenced approximately 40 criminal defendants, and some people might wonder if I've tried one federal criminal case as a federal district judge. How is it that I've sentenced defendants when I've only tried one case? And the reason is because, as everyone knows, most criminal cases are resolved by a guilty plea. Of my trials that I have conducted so far, one civil trial has been a sexual harassment lawsuit. That was a several-day trial on the civil side. Also, on the civil side, I conducted a trial in a case brought by the CFTC, the Commodities Futures Trading Commission, against an individual for allegedly selling securities improperly. And so really at this point, I've seen sort of the full panoply of federal district court litigation.
So in that time, you've seen the very kinds of cases that you would see, albeit in a different context, if you were confirmed to the U.S. Court of Appeals for the 11th Circuit. Is that right?
Yes, I think so. Also, these were the kinds of cases that I worked on when I was at the Solicitor General's office, too. Like I said previously, I argued 3 cases in the United States Supreme Court, 17 cases in the 11th Circuit, and those cases ran the panoply of all sorts of different kinds of cases, federal habeas cases. In particular, of my cases at the Supreme Court, I argued cases arising there from election law all the way to cases about railroad taxation. So I've seen the full panoply of federal law, I think, at this point.
So it'd be fair to say that in your career as a practitioner before becoming a judge, combined with your experience as a judge, you've been exposed to a wide variety of the things that you'd be called upon to review. You're familiar with both trial procedure, the type of trial procedure and judgment calls you'd be asked to make on the 11th Circuit, and you're also familiar with appellate procedure. And in that respect, I consider you very, very well qualified. And it's a shame, really, that more people can't have that opportunity. But that moment, while you haven't been on the court for an extremely long period of time, it's long enough for you to have been exposed to a lot of things. What's worse in your view? A court getting involved to invalidate a law whose unconstitutionality is suspect, or a court failing to invalidate a law that is constitutionally problematic?
Senator, I don't think there's a difference between those two things. I think in either proposition, the court has done something that they were not supposed to do, and it's the obligation of the court to say that a law is unconstitutional when it is, and it's the obligation of the court to say that a law is constitutional when it is. And in either of those propositions, I see both of those as equal errors.
In light of that fact, isn't it fair to conclude that judicial activism per se is not the enemy? It's certainly not the one and only enemy. Judicial activism is no better and no worse than judicial passivity.
Well, Senator, I think when people speak of judicial activism, they're oftentimes speaking of a judge supplementing his or her will for the legislative will and not following the law. I think that it's, like I said, what judges need to do is follow the law, follow precedents, and in particular, the role of a judge is to take decisions that are made by others in our system, by legislative bodies, by this body, by administrative agencies, by other judges through precedent, and to apply those bodies of law to new facts as they arise.
Mr. Chair, can I ask one more question on this line? Some critics of this approach to judging, or what many of us would simply call judging, say that it ends up producing results that some don't like or that are counter-majoritarian or anti-democratic. What's your response to those?
Well, if a judge is applying the Constitution as written, faithfully with the precedent from the Supreme Court and the intent, the original intent of the authors of the Constitution, then what the judge is doing is actually furthering the democratic process because those elements of the Constitution were adopted through the democratic process and they can be changed through the democratic process. I would say the same thing about statutes. If a judge is applying a statute, the text of a statute as written, faithfully with the text that was passed by a legislative body, then what the judge is doing is consistent with the democratic process because the judge's decision can always be changed through the democratic process.
Thank you very much. Thank you, Mr. Chairman.